So let's talk a little bit about sexual harassment in the general sense of it. There are two legal theories. One is quid pro quo, the other one is the hostile working environment harassment. And in the quid pro quo, sex is a condition of employment. So if you don't sleep with me, I'm not going to give you the job. If you don't sleep with me, I will not promote you. If you don't sleep with me, I will demote you. So there's all sorts of threats embedded in it. Um, it basically is a very clear exchange relationship, if you will. When we talk about quid pro quo, that's basically what it means. I give you this, you give me that. Hostile working environment is looking at an offensive working environment that interfered with somebody's ability to work. Now we've talked about race and national origin and things like that. That harassment and hostile working environment can be an essential part of that as well. This is specific to sexualization in the workplace, where we have an offensive, sexualized workforce or environment that is interfering with our ability to do a job because it's distracting and we feel targeted. The distinction between the two terms is not rigid, according to the Supreme Court, that there can be some blurring at the edges. Most harassment takes place, of course, between males and females, with the male as the harasser, but that's not 100% the case. We know that there are a number of cases where men are harassing men, women harass women, and that male employees can be the victim or the harassee, with 16% of the claims in 2018. The watershed case on this was Domino's Pizza, where a male assistant manager was being sexually harassed by his female manager. The EEOC took on that case and he won his case that he was definitely being sexually harassed. So don't assume, while most cases are male on female, in that sense, that doesn't mean that all harassment has to be male harassing female. It could be female harassing male. It could be male versus male, female versus female. Same-sex harassment is key to those cases, and there's some details on that we'll get into. So going into a bit more on quid pro quo, it's what it comes down to is an abuse of power, right? The harasser is requiring some sort of sexual activity, whatever it might be, whether it's simply a date or whether it actually is a sexual exchange, in place for workplace benefits. And it's a carrot and a stick. It's a reward punishment system that is really insidious because sex does not have a place in the workforce, meaning physical sex, the intimate act of sex does not have a place in the workplace, in workplace policies or workplace decisions. It is the more obvious type of sexual harassment, but it doesn't mean that it's the most popular either. I think we've sort of gotten to a place, or at least I'd like to believe that we've gotten to the place where most employers are not going to engage in that. Obviously it still happens. Obviously the whole Me Too movement, with respect to the movie industry, right, and the producer that was harassing all of the women that wanted to be in movies with him. He obviously was doing that within the last number of years, but I think we are seeing cases of quid pro quo decreasing over time, which is a good thing. It's really not difficult to recognize it. You'll know it when you see it. Come on, baby, sleep with me. Come on, you know you want that promotion. If you do, I can see what I can do to put in a good word for you. Blah, 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 blah. There are some exceptions, of course. Ball State University versus Vance. The harasser has the authority to hire and fire and not just direct work assignments. And so in order for this to work, to be quid pro quo, they have to have the authority to hire and fire, and not just direct assignments. In which case then, that becomes a form of, that's one of the examples of harassment as it got deeper into some nuanced descriptions of it. With respect to the hostile working environment, the harasser is creating an abusive environment or an offensive and intimidating environment. They're not directly asking for an exchange of sex for favors, right? The offensive environment is one in which the targeted gender is subjected to this intimidation or this offensive behaviors. Um, um, and it's not just one particular person, but it could be many women. Now, what happens if some of the women think it is harassing and some of the women don't? Um, the women who consider it harassing are still the ones that their point of view matters. So even if you have women saying it didn't bother me, if you have women that say it bothers them, that is that's the sort of the basis upon which the harassment is considered. Prima facie case, how do we determine it? The harassment has to be unwelcome by the harassee. The harassment is based on gender, so it could be sexy photos of women in that are nudes or in bikinis. It could be sexy calendars of naked men. It could be the same thing, right? But it has to be gender based. Harassment is sufficiently severe or pervasive to create an abusive working environment. The harassment affects a term or condition of privilege of harassee's employment, and the employer had actual or constructive knowledge of the sexually hostile working environment and took no prompt or remedial action. So here's the thing. You have to let the employer know that the environment is hostile. You have to inform them. I would inform them in writing. So you have a paper trail. Always have a paper trail. If you're going to be reporting that, you report it to them, and then once they know and they don't do anything about it, then you can charge them with sexual harassment and for a hostile working environment because you've given them an opportunity to remedy it and they have not done so. So here's a quick comparison between quid pro quo and hostile working environment. In quid pro quo, there's a workplace benefit that's promised, either promised, given to, or withheld from the harassee. Um, it's in exchange for sexual activity, and it's generally accompanied by a paper trail. And the hostile working environment, the harassee experiences behaviors from the harasser that is unwanted, is based on their gender. It creates a hostile or abusive work environment. It unreasonably interferes with their ability to do their job. It's sufficiently severe or pervasive. It affects a term or condition of the harassee's employment, and it's a basis for imposing liability on the employer because if they knew and they acquiesced and they allowed it to happen, then they are the ones that are liable. There is a requirement of what we call unwelcomeness. An unwanted activity by the harasser is the basis of hostile working environment. So it has to be unwelcome. If I tell you this is not okay and it's unwelcome, that's the clue that you're on the verge of a harassing situation. Meritor Savings Bank v. Vinson, it dealt with this particular issue that unwelcome does not mean involuntary. There were numerous sexual contacts occurred over an extended period of time, and they could be purposeful, but the environment is really the key here, and it's unwelcome. So what we know in scenario 3 is that because it's dynamic, consent is dynamic, what was formerly welcomed may no longer be welcomed. You can say, you know what, I've had enough and I'm done, please stop. So you have to have a direct request to say, please stop, or indirect, where there's a failure to join in or to show any disapproval. So someone's joking, but I walk away because I don't want to engage in the joking. That's a way of demonstrating unwelcomeness. Second, we'll talk about the severe and pervasive requirement. Severe and or pervasive activity means basically that the activity is more than an occasional act and it's so serious that it interferes with the nature of the job. So typically, if the more frequent or more physical or more humiliating the occurrences are, the more severe slash pervasive they are. So it's not a civility code. What it means is that the focus is on, can a person do their job without a pattern of unwelcome behaviors that make it difficult to operate as an employee. So what we mean by that is they have a right to be able to do this work without anything that interferes with it. I mean, we have some incivil moments in work. It happens. Once you put people together, there's always going to be incivil moments. But really what is at issue is not, the one time or the one off event or the occasional event, but it's a pattern of events that are unwelcome and they're sexually based, making it challenging for us to be able to do the work. This is also not about personal injury claim. Claims do not require findings of severe physical harm. So what we're talking about is you've created an environment, I can't get my job done, and this needs to stop here and now. That's what we mean by severe and pervasive. So how do we determine severity? As we talked about, what is severe and pervasive? So severity has been upheld since Rabideau versus Osceola's 1980s boys will be boys rhetoric. The reasonable person standard views the harassing activity from the perspective of a reasonable person, which tends to generally be a male view, right? The reasonable person in the workplace tends to be a male more than not. So now what we changed to what used to be the reasonable woman standard and now really is set up as the reasonable victim standard. So we're viewing harassment through the eyes of the reasonable person who might be a victim in this circumstance, and how would they or should they respond? Would a reasonable person find this behavior to be okay? So those harassing activities tend to include very gender-specific, sociological, cultural, and other factors. And that's the Ellison v. Brady case that was really important. So the two major cases, I mean, there's tons of them, but the two major cases are clearly the Ellison versus Brady and the Vinson case, which I don't have in front of me right now, and it's just slipped my mind, so I apologize. So then how do we then continue to determine severity? So the EOC issued a policy that the victim's perspective has to be included in here, not just generally the reasonable person. So it's a very unique and different standard than you might hold for other types of cases. The reasonable woman or the reasonable victim here, would a victim of this consider this to be harassing? The Supreme Court decision in Oncali versus Sundowner said the objective severity of harassment should be judged from the perspective of a reasonable person in the plaintiff's position. So the reasonable victim. So if you're a woman in that harassing situation, would the average woman consider that to be harassing? If you're a victim in this circumstance, would the average victim consider this to be harassing? So while traditionally we have thought of sexual harassment as requiring some degree of sexual innuendo or sexual activity or sexual comments based on intimate sex, but there can also be an anti-female animus that goes on. So where there is hostility towards women or their ability to perform jobs, when we do engage in sexual stereotyping, so it can also be considered a form of sex discrimination. And it's usually negative language and actions that dictate this. And the Andrews versus Philadelphia talked about vandalism and harassing vandalism that was directed at female officers, and that was considered a hostile action and created a hostile working environment in an anti-female context for women to be in that workplace.